Hello and welcome to another webinar in the Axum Global webinar series. Today we're going to talk about how to deal with the legal consequences of a data breach, and hopefully for all of us listening to Jeremy to also learn how we can sleep well at night once something like that has actually happened. Before I hand over to our speaker today, a couple of housekeeping items. First of all, you will be muted during the presentation, but on your webinar client, you've got a questions section where you can submit questions to the speaker. As you might have seen on the agenda, we'll have a Q&A at the end of the presentation. So if you've got any questions that come up throughout the presentation that you would like to ask, please put them into that question section and we will respond to the questions at the end of the webinar. Should we run over time, we will provide the answers in an FAQ after the webinar. After the webinar, we will also provide a recording of this webinar that will be made available on our website as well as our YouTube channel, and we will also send that link to you. And then obviously, please do follow us on LinkedIn and Twitter for news and upcoming webinar announcements. Okay, with the introduction and the housekeeping done, it is my pleasure to introduce our speaker today, Jeremy Holt, whom I've had the pleasure of working with over the last couple of months, and I very much look forward to this presentation today. So Jeremy, I'll hand over to you, let you introduce yourself, and then I look forward to your presentation. Thank you very much.
Okay, thank you, Andrew, much appreciated. Right, first of all, I'm going to explain what I'm going to talk about. Then I'm going to offer you some reasons for listening to me as opposed to anybody else on this subject. What I want to talk about are the legal consequences of a data breach. The legal consequences of a data breach. These things will happen and you will have to deal with them, and you need a procedure to deal with them, and I don't want you to worry about these any more than is necessary. So I hope you will worry about them slightly less by the time that I finish this presentation. Now, whenever I hear a presentation, I get very cross if the speaker does not introduce themselves at the start. So who am I? I'm Jeremy Holt. I'm an English lawyer. So a lot of what I'm talking to you about today is based on English law within the EU, but I will try to give it as much of an international aspect as possible, and I'll explain why what is happening in the EU is likely to be exported in a similar way to other countries in future, to the extent that it hasn't already happened. So I'm an English lawyer. I co-founded a firm of solicitors 24 years ago. I'm very interested in the computer industry. I spent 15 years trying to get the first specialist computer museum off the ground in the UK, and that was eventually founded 15 years ago. I'm the chairman of that museum, and so it's been going quite happily for the last 15 years. I have worked in this field for more than 40 years, which is unusual because it wasn't going on too much before 40 years ago. And the final thing is I've written 2 extremely dull books on the subject of IT law, which are available at all bad bookshops. Right. Now, I know that some people have a problem in actually understanding what data protection is. So I've developed a chart which sets out the different actors in this drama. Now, data protection arose in Scandinavia, and then, like the Vikings, came south in the early 1980s, because it was felt that those in possession of computers had the balance of power over individuals about whom they had information on those computers. And it was thought that the law needed to step in to protect the rights of individuals. Now, look, if you look at the chart and look on the left-hand side, you'll see the data, a box marked data subject. Now that is the individual. It's a living individual. It can't be a company. It has to be an individual. Now, if you take an example of, I'll use the word data subject quite often later on in the presentation. Let's say the data subject, you, subscribe to a magazine. You therefore give your personal data, if you follow the line saying donation of data, to a data controller. So the magazine that you are subscribing to is the controller of your data. Now, it may be that the magazine doesn't host the data on their own servers, but puts the information up in the cloud. The cloud supplier will be the data processor who's up at the top of the chart. Now, they're not particularly interested in the data at all. They're just a hired hand who've come in to do some work for the data controller. It's the data controller who effectively owns the information and has the long-term interest in it. The data processor will simply process this information for as long as the data controller pays the data processor to deal with it. The magazine may pass the information on to other people, so hence the box in the top right-hand corner, either within the European Economic Area or outside it. There needs to be appropriate security for the personal data. Now, the data controller will be subject to what's called the supervisory authority in the bottom right-hand corner. The supervisory authority is the government officials whose job it is to sort out, control, and monitor what's happening with the data controllers in their particular country. In the UK, the supervisory authority is the Information Commissioner who runs the Information Commissioner's office. But in other countries, there will be a different supervisory authority. And wherever you are based, it's likely to be the case that you will need to liaise, perhaps register with the supervisory authority. Now, one of the big issues in data protection at the moment is that you're not allowed to hold information forever. And that's why at the bottom box, eventually, that information will need to be destroyed, because there will become a point, let's say you as the data subject cancel your subscription to the magazine. I mean, frankly, a year later, that magazine should destroy your data because they've got no further reason to hold your personal data. Then down in the bottom left-hand corner, the magazine may have got your personal data from a third-party list supplier, may have written to you with a letter saying, hi, would you be interested in subscribing to our magazine? Though the sale of personal data, because of recent legislation, which I'll talk about quite soon, is now much more restricted than it used to be. So, okay, that's the chart. That's how everything fits together. Data subject, who's the individual, gives it to the data controller. The data controller may pass that personal data for processing only to a data processor. There, if you just remember that part, I think that would be helpful. So if I just run through data controller, the person who owns the data, we can move on to the next slide. We've got the naming of parts here. Data processor, somebody has no long-term interest in it, it's just doing a job for the data controller. Data subject has to be a living individual. It's got to be a human being, a living human being. Now, within the EU, there has recently been, last year, some new legislation came in called the General Data Protection Regulation. The General Data Protection Regulation, which is abbreviated to GDPR. That applies all the way through the EU and also to 3 countries outside the EU, Norway, Iceland, and Liechtenstein. So that's a bedrock level of minimum data protection legislation all the way across the EU. Now in Britain, or in the United Kingdom, what we did was we just implemented what we were required to do. Now in some EU countries, such as Germany and Austria, they have much stricter rules about data protection than what is set out in the GDPR. Just to give you an example, in the United Kingdom, we have one information commissioner. If you go to Germany, there's effectively an information commissioner, certainly in every large city and in most large towns. Then finally, on the list of definitions, we've got personal data. Now that is information about the living individual. Now it may well include the name, but it's not necessarily the name, because if you have other information about them which would allow you to work out who the individual is, because address, height, medical background, relatives or anything like that, then that still counts as personal data, even if it doesn't actually include the individual's name. Now, just before I go on to the definition of personal data, if I set this in an international context, the EU has what's known as a whitelist of countries where it is okay to pass personal data out of the EU to, because those countries are regarded as having an acceptable level of data protection. Just to give you a few examples, those countries would include Argentina, Israel, Australia, New Zealand, and Singapore. So there are various countries which are on the whitelist. Obviously, there are some countries which are not on the whitelist, and the two that are most prominent from the work that I do are the United States and India. Now, the unashamed aim of the European authorities is to try to encourage other countries who don't yet have a level of data protection to copy in some form the GDPR. So it will make it easier in future for us to make international transfers of personal data around the world, because it will leave one safe place and go to another. So hopefully the list of countries about whom the EU authorities have made an adequacy decision about will grow as time goes on. Okay, so I think I mentioned earlier, personal data is information about living individuals. Need not be their names, but if you can work out who the individual is from other identifying factors, then that still counts as personal data. Okay, well, that's fine. You are entrusted with personal data, but things can go wrong. There can be a personal data breach. What is a personal data breach? Personal data breach refers to a breach of security that can lead to, each of these need to be looked at carefully, the destruction, the loss, the alteration, and the unauthorized disclosure of or access to personal data. Now, I think most people, if they were to think about a personal data breach, would think of a third party, either intentionally or unintentionally, getting access to the personal data. But if I just run through a few other examples, that's one of the principal ones, but there are others. It could be the loss of personal data on a particular piece of hardware, such as a smartphone, tablets, laptops, mobile devices, or even loss of paper records. Paper records are still covered by this. It's not just computers. That's a widespread myth about it. It would cover people faking that they are one of the people inside the organization. It could be a data processor, such as a website hosting company, which identifies an error in the code, which allows other people to have a look at it. So there's a huge number of different kinds of personal data breach there. As I mentioned, if you look at the description there, we've got the destruction, loss, alteration, and unauthorized disclosure or access to the personal data. Now, under GDPR, if you are the data controller, you are required within 72 hours to report that personal data breach to the supervisory authority. I'll just go through that again. Within 72 hours, i.e. within 3 days, it's got to be reported to the supervisory authority. I think the logic for this is so that the supervisory authority knows what's going on. They can keep tabs of the problems that people are having. Now, I came across recently where one of my clients discovered a personal data breach on a Friday. I think a lot of people's responses to discovering they've got a personal data breach will be to pick up the phone to their lawyer. I jolly well hope that is the case, because otherwise I'm likely to be out of a job. But the problem was, it was a public holiday in England on the Monday. And so, you know, our office was closing on the evening. And, you know, if they had to wait until the office reopened on the Tuesday, we would have got past the 72-hour period. My experience of these is that people very rarely report them before about 70 hours. So the crunch period is between 70 hours and 72 hours, so they can just get it in there. Now, the principle is that you don't need to report the breach if there's only a low risk to the data subjects. The problem is there's no settled idea yet of what low risk means. On one occasion, I was dealing with a data breach, and you know, I obviously know my opposite numbers of other IT lawyers, and I spoke to them on a no names basis, and I rang them, and half of them thought it should be reportable, and half of them thought that it shouldn't be reportable. Now, ladies and gentlemen, listeners, lawyers are a cautious breed, and so if there's a choice between doing something and not doing something, and there's a requirement to do it, a lot of lawyers will take the safe approach and say, well, it doesn't cost anything to report it. The worst thing that could happen is that the supervisory authority might come back to and says, hey guys, you didn't need to report this, but if there's any doubt about it, let's report it. I mean, if you take the view that there isn't much of a risk, it's a low risk for the data subjects, but later you discover that that is no longer the case, when you make that second discovery, you could report it within 72 hours there. So if we can move on, yes, if we got the how to report a breach, within the European Union and Norway, Iceland and Liechtenstein must be reported within 72 hours. You've just got to do the best that you can. It's the nature of these things that you do not have all the information about the personal data breach straight away. You're still feeling your way around, trying to work out what on earth happened. And certainly in the UK, there was no obligation to report personal data breach before GDPR came in 2018, but there is now. Just to recap, if you are the data processor, as opposed to the data controller, you report it to the data controller. You don't report it to the information commissioner. Now, my experience of dealing with data is that the data controller will obviously often have a data processor, and then there will be a data sub-processor, and then there will be a data sub-sub-processor. And so there can be a long chain, perhaps 6 or 7 long. So in that chain, each person in the chain reports it to the person a bit higher than them in the chain until it eventually comes to the data controller. And it is the data controller's responsibility to report it to the supervisory authority. So just to recap, you do have to report it unless there's only a low risk to the interests of the data subject whose data has been lost or affected or stolen or whatever. Now, our information commissioner in the UK provides a kind of standard notification form that you can tick to provide that. Now, that information that you have to provide is not simply details of the personal data breach. You do have to talk about the personal data breach, and so far as you can, within that 72-hour period, report as much as you know. And as even more depressing information comes into you or is discovered after that 72-hour period, it is legitimate to bring the supervisory authority up to date with what you've discovered later about information that you simply did not know within the 72-hour period. You've got to give details of who the individuals were. You've got to give details of what kind of personal data was concerned in the data breach. You've got to give a contact person within your own organization. Now, some organizations by law will have to have a data protection officer. But most, in my experience, most companies do not need to do that. However, it is always good practice, and I would advise any organization that there should be somebody in the organization whose job it is, among other things, to deal with data protection, so that they can act as a lightning rod, that if there is any problem, people know to whom to turn and who to report the problems that are going on. You've also got to try to foresee what could happen. Okay, let's think of something where it would just be pretty ghastly. I can remember reading about a case of an HIV clinic in London, you know, that dealt with patients with AIDS, that was going to close for a weekend, and they sent an email to all of their patients saying that they were going to be closing for the weekend. However, unfortunately, they didn't put it in the blind copy box. They put it in the open copy box, the open CC box. And so each of the patients saw the identity of all the other patients. I mean, that is undoubtedly reportable, and it gives you an idea of the sort of sad things that can happen unintentionally. I mean, that wasn't deliberate, that was just human error. Now, research has shown that at least half of data breaches are as a result of human error. It's just one of those things. We live in an imperfect world, stuff happens, people make mistakes. Okay, right, we just have to deal with it. If one of your members of staff makes a mistake and there's a data breach, unless there's an extremely low risk to the data subject, you're going to report it. Certainly my experience is actually you don't hear much from the supervisory authority, presumably because they're swamped with people reporting things. But the point, sorry, this is slightly elliptical. I mentioned earlier it wasn't just about the data breach itself concerned. You also have to tell the supervisory authority when you report the data breach, what steps, what measures you are going to take to mitigate the risk for the individuals, and also to try to prevent the mistake from happening again. So I'll just run through that again. As well as reporting the details of the personal data breach, you also have to do a bit of navel gazing and look to see how you can prevent this from happening again, which of course is good management practice. You should learn from your mistakes. And secondly, how you can reduce the risk for the particular data subjects concerned. Now, one of the ideas in data protection, which came in from the States to actually get people to take these things seriously, is to put a requirement on the data controller to tell the particular individuals concerned of what's happened. So not only do you have to report it to the supervisory authority, put your hands in the air and say, hey guys, sorry, we had a data breach, personal data breach here. This is how many records it was. These were the people. This is the information that got out. These are the steps that we're taking. This is how we're going to mitigate the loss. Now, this next step, I can tell you, is what businesses do not want to do. If there's a high risk, to the individual, and certainly the example that I gave about the HIV clinic in London, the AIDS clinic in London, that would certainly be a situation where there was a high risk to the individual. Not only do you have to report it to the supervisory authority, but you've also got to contact the particular data subjects themselves, if you can, because you may no longer have their information or you may no longer have their contact details. And if you can't do that, you've got to advertise publicly in magazines or newspapers to try to get that message across to those people, to those data subjects. Now that, I can tell you, ladies and gentlemen, is something that businesses do not want to do, because they're basically telling the whole world that there's been a cock-up, that there's been something terrible. Of course, the press love this kind of stuff. It's free copy. They don't have to do any work to pick it up. And then they republicize it, or I suppose they help the organization publicize it to make it easier for the data subjects to find out. Now, that idea came in from the United States. I think California was one of the states that implemented it fairly early on, and it's slowly being adopted on a state-by-state basis across the United States, of having to contact the data subjects to tell them that there has been a problem. And in theory, so what's the risk? What's the worst that could happen? Okay, first of all, the supervisory authority can levy fines on the data controller, and for that matter on the data processors as well, because they're still subject to these rules. And sorry, I should have mentioned this earlier, each of the data processors, even if there are data sub-processors, have to report it to the next person up the chain within 72 hours. So it doesn't matter whether you're a data controller or whether you're a data processor, you have to do something within 72 hours. If you're the data processor, you've got to report it further up the line to the data controller. If you are the top of the chain, within 72 hours, if you're the data controller, you've got to report it. You've got to report it to the supervisory authority. Both data processors and data controllers are potentially subject to fines. The fines are horrendous. The maximum fine is either 20 million euros or 4% of your turnover, if greater. Now, that is one of the reasons why lots of people are taking data protection much more seriously than they used to. Most of the commercial contracts that I deal with have a section in them about data protection. In the old days, we didn't look at these things as much as we do now. And often liability under contracts is unlimited because people are worried about the amount of fine that they might face as a result of that. So there could be fines. There can also be a class action brought by the data subjects affected for any loss that they suffer. We haven't yet seen that happen in the United Kingdom, but obviously it's something that happens quite a lot in the United States and elsewhere. And I think that will be something, it's not something that we as a law firm deal with because we don't deal with litigation, but there will be specialist law firms that deal with litigation and that are in a position to bring a class action on behalf of hundreds or thousands or millions of data subjects who are affected by a particular data, personal data breach there. Okay, so how do we avoid this happening? What are my top tips? Okay, my attitude on this is that some things in life just happen. We have fire insurance in case your building burns down. There's no way we can stop fires from happening. We can reduce the risk. We can mitigate the risk that if the building does burn down, we can go and claim on insurance. So, okay, you know, if you were to say to me, well, it's very clever of you, the lawyer, pointing out all this sort of problems. What do I need to do? How do I actually reduce the risk? Okay, no particular order, Number one, there needs to be one person in your organization, or more for this matter, whose job it is, plus other things, to deal with data protection. So if there is a problem, if a member of your staff discovers that there is a data breach, they know who to turn to, because subject to this, you're subject to this 72-hour reporting deadline, whether it's to the data controller or whether it's to the supervisory authority. It doesn't make any difference what hat you're wearing. So there needs to be one person there, because everybody in your organization knows who they need to speak to. Now, that person who's in charge of data protection should have a procedure for dealing with the data breach, even if it's simply the number of the lawyer to ring to discuss what on earth they're going to do next. So single point of contact and a procedure. Don't wait until the horse is bolted to shut the stable door. Sorry, that's an English idiom. If you're not from the United Kingdom, I've been trying to avoid English idioms as much as possible in relation to that, because I know how many foreign listeners we're lucky enough to have for this. Next point, second point, is don't rush. You've got 72 hours. My experience, very few people report it within 70 hours. Virtually everyone reports it within 72 hours. So that last couple of hours, they're leaving it later. They're leaving it to the last moment. You've met the requirement if you report it within 72 hours minus 1 minute. They wait to find out what's going on. So don't rush. Don't rush into a knee-jerk reaction. Have a degree of objectivity. Remember that you don't have to report the data breach if there's only a low risk to the data subject. And if you think there's a low risk to start with, but that changes later, it is acceptable when it changes later, or you make a discovery later, to report that then to the supervisory authority. And thirdly, you are going to look quite silly in front of the supervisory authority if you have not provided your staff with data protection training. And you need to get that data protection training organized when your new staff walk through the door. There's no point just doing it once a year, because you could have somebody who's there for almost a year who's had no data protection training at all. You need to have everybody who has any access to personal data to receive some form of, some kind of regular form, perhaps annual training in reminder training in data protection. But also, as people arrive, they should be given some training in that. So as they hit the ground, they've got some kind of idea of what's happening. And don't forget, it's not just your members of staff, the ones that are employees of yours. This would also apply to contractors who are coming in and who are working under your direction within your own business. So it covers both employees and contractors. It's going to be no defense if the supervisory authority says, well, you know, what arrangements did you make for these contractors who you were using to process this data or to deal with this? I mean, you know, when did they get any training? And you say, well, actually, I didn't provide any training. You know, that's not going to be helpful. And fourthly, in my top tips, remember data protection. And when you're entering into commercial contracts, try to work out whether you are passing personal data over to someone else. If they are going to be processing personal data for you, you need to have a section of the contract. Now, I'm sorry about this. I spend a great deal of my life trying to make contracts as simple as possible and short as possible. Now, I have run into a brick wall in relation to data protection, because however much I try to shorten it, if there is going to be any processing of data, I'm afraid there's going to have to be at least 2 or 3 pages that deal simply with data protection in order for you to comply with the requirements on you. Sometimes I actually put it in the agreement. Sometimes I put it in a separate schedule at the back or in a separate addendum, simply because sometimes it's better to put it in an addendum or a schedule, because otherwise it would break the flow of the agreement of people reading through the contract. Finally, just there is an end to this presentation in case you were worried. Partly as a result of GDPR and new data protection legislation, there is a rise in cyber insurance. Some people are taking it out, some people are not. No, not breaking any great secrets to say we as a law firm are starting to look at it very seriously, because obviously we're in possession of a considerable amount of quite sensitive personal data or secret personal data. So again, as I mentioned earlier, lawyers are cautious animals, so we would be attracted by the idea of some kind of cyber insurance, as well as dealing with the supervisory authority, as well as trying to make sure it doesn't happen again if you have a personal data breach, as well as perhaps having to tell the data subjects. You may, if you have cyber insurance, be able to claim under a cyber insurance policy. So even if the worst happens and you have problems and there's a loss of reputation and you have to employ extra people to try and deal with the problems, and you have to employ a PR company to try and deal with this, to help you deal with it, you may be able to make a claim under a cyber insurance policy if you have insurance of that case. So I think the last thing that I'd mention to you is, don't forget, you may be able to recoup some of the losses that you have by making a claim on any insurance that you might have. Now, obviously, the person who's in charge of data protection in your own organization should know whether there is any such insurance, because otherwise they won't be able to take advantage of it. So if you have been, thank you for listening, and I'm happy to take any questions that people may have on what I've said, even if the question is, what have you been trying to say?
Thank you very much, Jeremy. That was very interesting and informative and very thorough. Definitely got a much better picture of what is involved. We do have a couple of questions. I'll start with the first one. It's probably an easy one for you, but you've been talking or referring largely also to GDPR throughout your presentation. And the question really has got sort of two elements to it. One question, so sub-question one is, how does that affect anybody outside of the EU? And does GDPR affect anybody outside of the EU? And then secondly, what have any of the statements that you made, what relevance have they got if we're looking at other similar acts, I think that you referred to as well? I mean, like the California Privacy Act or the Singapore Personal Data Protection Act or other similar regulations. So what relevance have your statements got to those?
Okay, very good question. I apologize. I should have talked about the extraterritorial aspect of GDPR. One of the reasons why GDPR had such a big effect on the worldwide business community is, even if you're not based in the, well, first of all, GDPR applies to anybody who collects any information about anyone, whether they're Bushmen in the Kalahari or whatever, within the confines of the European Union and Norway and Iceland and Liechtenstein. So anybody who collects any personal data about anyone in the world within the European Union will be subject to GDPR. That's the first part. So anybody collecting personal data within the European Union, even if all the people that you're collecting the data about are outside the European Union, GDPR applies to you. First part. Second part, and this isn't so widely known, if you are based outside the European Union, but you are collecting information about EU citizens, I'll just run through that again. If you are based outside the European Union, you've never set foot in the European Union, but you are collecting personal data about EU citizens, GDPR also applies to you, with all the horrendous fines potentially that I mentioned, with all the obligations to report data breaches to the supervisory authority. Now, I do realize that the enforcement of GDPR outside the European Union is going to be a problem for the supervisory authorities. So there are various technical issues there. But anybody outside the European Union collecting information about EU citizens, GDPR, there is no doubt about it, does apply to them. I'm sorry, I should have mentioned that earlier on in the presentation. I was overcome by emotion. Secondly, what relevance do the statements have? Now, I am not an expert in the California Privacy Act, nor am I an expert in the Singapore Personal Data Protection Act, but I know that any country which has data protection legislation and which has been recognized by the European authorities as having adequate data protection will, broadly speaking, have a similar system of data protection legislation as there is under GDPR. It won't be exactly word for word, but it will have a similar principle. And the reason why those other countries have a finding of adequacy by the European authorities is that the European authorities feel that personal data in those countries is protected to a reasonable extent. And so there's no hemorrhage of information that might be taken outside the European Union and moved to one of these other countries which are on the white list: Argentina, Israel, Canada, Australia, New Zealand, Singapore, there. But be careful about it, the United States. I know there is the issue about safe harbor, or privacy shield now. It used to be called safe harbor. It's now a different system. And also be careful about the export of personal data to India. Okay, I hope that's provided a satisfactory answer to that question.
Thank you, Jeremy. I would just want to remind the listeners, again, if you've got any additional questions, and I've got some more here, please put them into our question box. We'll try and answer as many of them throughout the presentation as we can. The next question I have for you is, I understand that the overall structure and the requirements for the presentation, but what should I do, I guess, both as a data processor as well as a controller, so that I can, as you said in the beginning of the presentation, so I can really sleep better? So I mean, what are some of the must-do things that I should prepare today to make sure that whenever something happens, I'm in control and I can really sleep well? Okay.
Well, many years ago, I used to be in the British military. We used to have a sort of catchphrase that knowledge dispels fear. Knowledge dispels fear. I mean, what happens is you can't just ignore data protection. It's not realistic. You could ignore it, but it's going to come back. It's going to bite you at some point. We live in an imperfect world. You need to tackle data protection head on. You need to recognize the fact there will, at some point, somewhere, sometime, be a personal data breach. So you need one person in your organization, one or more, whose responsibility it is to deal with data protection. You need to have a procedure, so if there is a data breach, it's reported to that person and they know what procedure and processes to follow. They don't need to rush at it. They need to take a breath, sit back. Well, what do we know so far? What has happened? Why do we think that has happened? What is that likely to mean for other people? How serious is it? What can we do to mitigate the loss? What can we do to try to prevent that from happening? Okay. Next point, everyone who joins your organization, who has any access to personal data, and it may just be the person on the front desk who collects the information about your visitors, even someone like that, you know, is handling personal data, and they should get some kind of training when they start. And in my experience, most good organizations provide training at the start as part of the induction process, but they also have an annual reminder, a bit like fire precautions. You know, in my firm here, we have an annual reminder about fire precautions. It's also good practice to have an annual reminder about data protection implications. And also, businesses make money by having contracts with other businesses. When you make a contract with another business, if there is any transfer of personal data at that point, question, do we need to have anything in the commercial contracts about data protection? I can't help you never have a personal data breach. What I can help you with is to outline the precautions, the processes, the procedures that you need to take to reduce the risk and to mitigate the consequences of that point. It would be a lovely world if there was never a personal data breach, but unfortunately we don't live in that lovely world. We live in the world as it is. So stuff will happen from time to time. The clever people are the ones who pick themselves up and just deal with it so far as they can, as opposed to panicking or just burying their head in the sand. Okay.
Thank you, Jeremy. The next question is related to being a data processor. So the question is, I'm a data processor. You were clear during the presentation that the owner of the data is the key entity that needs to report. But what is my exposure as a processor, if any?
It's a very similar set of rules to the legal rules under GDPR in relation to a data processor are very similar to those in relation to the data controller. GDPR marked a new step in data protection in the EU, because prior to that time, certainly in the UK, some of the other European countries, there were no legal rules about data processors. They only applied in relation to data controllers. But now the rules apply to both. There's no doubt about it. I think partly because of the proliferation of the number of data processors, the law recognized that there was now a substantial amount of information being held by data processors, and it was sensible to extend the law in a big way to the data processors. There were one or two rules on data processors, but they were relatively minimal. Now, the same phalanx of legal rules apply to data processors, and just to remind everybody, if the data processor discovers a personal data breach, now this will be a nightmare for cloud companies, because if they have a personal data breach, they're going to have to contact all the customers, you know, whose personal data they've been given, but who they've received personal data from. Sorry, just about to sneeze. There you are, a world first, an international sneeze. So if you take the example of a cloud company, which is a data processor, there's a big problem or a leakage or someone breaks in or they lose information, they're going to have to tell their customers, who are the data controllers, and then those data controllers may well have to go and tell the supervisory authority, and those data controllers may well have to contact the individuals, data subjects, about what had happened. So GDPR and personal data breaches are a big issue for cloud companies, and so it should be, because I mean, cloud companies are lucky enough to be holding massive amounts of personal data about people, and you know, the greater the amount of personal data that you hold, it's not unreasonable, the greater are the responsibility on you to keep it secure and to keep it secret.
Okay, thank you. I've got one last question for you, which is really look a little bit more into the future. So the question here is, what, if any, future developments and trends do you observe around data privacy in Europe and globally, and anything that any one of us should be aware of?
Okay, that's a good question. What you're asking about is which direction the law is going to go in. Of course, lawyers, being cautious, they will always quite happily tell you what the law is. If you ask a lawyer what the law might be in future. There's generally a sort of sucking in of breath, and well, it could be this, it could be that, and all the rest of it. I think realistically, the law is not going to get less strict. It is going to get stricter at some time in future. GDPR, one aspect of data protection in the world, marks a sea change here in increase in importance of data protection. And I can see there being a similar kind of legislative change, perhaps in another 5 or 6 years. The law is always struggling to catch up with what's going on. The law is always having difficulty catching up in the developments in the way in which the computer industry is developing there. Now, one particular aspect that's going on in the EU at the moment is the rules about being able to approach individuals to sell your services. And there's a draft e-privacy rule that's coming through at the moment, which we're all studying very closely, and that will come to fruition at some time over the next couple of years. And these will be the rules under which, whether you can or you can't contact particular individuals. So in a nutshell, you're not allowed to contact an individual as opposed to a business unless you've had some kind of previous contact with them before. And by individual, it's where the individual has the personal contract for the domain name that they hold. So if it says @gmail.com, that's a good example of something that's likely to be an individual email address. Relatively few businesses operate from an @gmail.com email address. So it's not going to get any less strict, it's going to get tighter. I think we're going to have more countries around the world taking data protection seriously. The law is always going to catch up. Who knows which direction the computer industry is likely to go in the next 5 or 10 years. But certainly the law will not have dealt with that adequately by the time it happens. And so it will be seeking to implement changes. You know, look at how unpopular the FANGs are at the moment. Who knows which direction different nationalities nations are going to take to actually deal with those large media companies that hold considerable amounts of personal data. So yeah, that would be my answer to that.
Okay. Well, thank you very much, Jeremy. I think that sort of gets us to the end of the questions that we've got here. So thanks again very much for taking the time to present to us today. It's very interesting, learned a lot. And I would like to thank the attendees as well for attending this webinar. As said, this webinar is going to be posted on YouTube and our website in the coming days. Thank you very much, and goodbye.